Welcome to Housing Market Savvy, the podcast where we cut through the noise and give you the real information you need to make smart decisions in real estate. I'm your host, Pat Kapowich. I've been protecting Bay Area home buyers and sellers for decades, and there's one thing I've learned in my career, and that the details matter. Today, I'm launching a new series in this show that I'm really excited about. I'm calling it Laws That Didn't Get Much Attention. Because here's the thing, in California, thousands of laws are passed every year, and dozens have a residential real estate aspect to them. Now, most people never hear about these laws, not from the news, and sometimes not even from their own real estate agent. So today, I'm going to change that. And for our first episode in this series, I want to talk about a law that could save you, I'm not exaggerating here, tens of thousands of dollars in repairs and or litigation, maybe more. It's called Assembly Bill 968. It went into effect July 1st, 2024. And if you're buying or selling a home that's been recently renovated, you need to know about this. I'm going to leave additional resources, links to the actual law, and some guidance in the episode description. Now, before I get into the details of Assembly Bill 968, I want to share something with you. The actual law, Assembly Bill 968, uses the term single-family residential property. Pretty straightforward, right? But here's where it gets interesting. I was recently on a legal update webinar with the real estate attorneys at the California Association of Realtors, where this exact law was included in a discussion, and their legal department has issued guidance stating that the law should apply to all residential 1 to 4 unit properties, not just single-family homes. Why the difference? The California Association of Realtors understands that the transfer disclosure statement framework, which Assembly Bill 968 ties into, already covers 1 to 4 units. They're recommending a higher standard of care and practice. So if you're buying or selling a duplex, triplex, quadplex, condo, townhouse that's been recently renovated, my recommendations and the recommendations of the real estate attorneys at the California Association of Realtors is to treat it as if Assembly Bill 968 applies. That's the kind of consumer protection for home buyers and risk management for home sellers that protects everybody. All right, let's set the stage here. In a hot market, Silicon Valley, San Francisco Bay Area, in any market for that matter, really anywhere in California, home flipping is big business. Someone buys a property, pours money into renovations, and sells it a few months later at a profit. And when it's done right, everybody wins. The neighborhood improves, the dated house becomes move-in ready, the home buyers get a beautiful home. Here's where it gets interesting, and by interesting, problematic. Some home flippers, not all, but some, cut corners. They hire unlicensed contractors, they skip permits, they install gorgeous countertops and fresh paint, while the electrical behind the walls hasn't been touched since 1965, and the plumbing looks great until you realize it wasn't done to code back in 79. There is an old phrase in this industry. It's called lipstick on a pig. I'm not a big fan of that term, but you get the picture. Beautiful cosmetics hiding structural problems. And the home buyer, they find out 6 months later when the shower starts leaking into the kitchen ceiling, or the electrical panel trips every time they run the dishwasher and the microwave at the same time. By then, the home flipper is long gone. The contractor who did the work, good luck finding them. And the leverage as a home buyer, extremely limited. This is one of the real estate conflicts that the public typically doesn't hear about, but since I attend a lot of legal updates throughout California, especially by Zoom, I get to hear about it on the legal side from the real estate attorneys. Now, the state of California finally did something about it. Assembly Bill 968 signed on July 21st, 2023 by our governor, it went into effect on July 1st, 2024. It's now codified as Civil Code Section 1102.6H. Here's the key trigger. If a home seller has owned a single-family residential property for less than 18 months, and remember the California Association of Realtors real estate attorneys recommend applying this to all 1 to 4 unit properties, condo, townhouse, duplex, triplex, quadplex. They now have additional disclosure obligations when they sell. 18 months, that's the magic number. And it applies to any home seller who accepts an offer on or after July 1st, 2024. So what do they have to disclose? 3 categories. Requirement number 1, a complete list of all work. The home seller must provide a complete list of any room additions, structural modifications, alterations, or repairs made to the property since they acquired title if the work was performed by a contractor. Think about what that covers. Kitchen remodel, bathroom renovation, new roof, foundation work, electrical upgrades, HVAC replacement, basically anything significant that was done to the property. Requirement number 2, contractor information. The home seller must provide the name and contact information for every contractor who performed work totaling more than $500. That's labor and material combined. $500. Let that sink in for a moment. In the world of home renovation, $500 is nothing. A bathroom tile job, way over $500. A new water heater, over $500. Electrical panel work, definitely over $500. That threshold means virtually every contractor who touched the property needs to be disclosed. And here's why that matters. Legitimate contractors stand behind their work. They have licenses, they have insurance, they can be held accountable. Unlicensed handymen and fly-by-night operators, they don't have the resources and they tend to disappear when the problems show up. Requirement number 3, permit documentation. The home seller must provide copies of any building permits obtained for the work. Or, and this is important, if the home seller doesn't have the building permits themselves, they have to tell the home buyer how to get them, either from the contractor or the local building department. This is huge. Unpermitted work may affect your insurance. It might kill a future sale when you want to sell down the road, and it could result in fines, mandatory repairs, or even demolition orders from building authorities. Now, you have the right to know about building permits, or at least to know how to verify them before you consummate the transaction. So we've covered what the law requires. Now, let me tell you why I think this is such a game changer. 3 reasons. When a home flipper has to name their contractors, they can't hide behind anonymous work anymore. And if something goes wrong 6 months after you move in, you know exactly who did the work. You have the names, you have the contact information. That's leverage you didn't have before. Second, permit verification. I cannot stress this enough. Before Assembly Bill 968, home buyers were often flying blind on building permit status. You'd ask about building permits, get a shrug, and hope for the best. Now, homeowners, within that 18-month window, have a legal obligation to provide building permit documentation or tell you how to verify it yourself. Building permits are public record. You can check with the building departments. That's real transparency. Third, legal leverage. And this might be the most important one. If a home seller fails to disclose required information under Assembly Bill 968, you as a home buyer may have grounds to rescind the sale or pursue damages. That's real legal protection that simply did not exist before July 2024. Let me say that again. Non-disclosure can mean rescission or damages. That changes the calculus for home sellers within that 18-month window. It creates real incentive to be transparent. Now, I want to clarify something important here because people hear home flipper disclosure law and they assume it applies to professional house flippers. That's not quite right. The law applies to any home seller who owned the property for less than 18 months and had contractor work done, any home seller. Say someone bought a home, got transferred for work, and is selling sooner than they had planned. If they had renovated the kitchen before listing, Assembly Bill 968 applies to them. They're not home flippers. They're just someone who had to sell quickly. But the disclosure requirements are the same. The law is triggered by the timeline, 18 months, not by whether someone calls themselves a home flipper or an investor or just a homeowner who had bad timing. Remember what I said earlier. While the statute says single family, California Association of Realtors legal department recommends applying this standard to all 1 to 4 unit residential properties. It's also worth noting that this law works alongside the existing transfer disclosure statement requirements. The same exemptions apply: foreclosure, certain estate sales, some trust sales, probates. For most residential transactions involved in recent renovations, this law is in play. So if you're a home buyer, and especially if you're looking at a home that seems like it's been recently renovated, here's what I would do. Step 1, check the ownership timeline. How long has the home seller owned the property? This is public information. Your real estate agent can also help you find it. If it's under 18 months and there's been renovation work, Assembly Bill 968 disclosure should be part of your transaction. Step 2, ask specifically about Assembly Bill 968. Don't assume the real estate agents know about this law. Ask them directly. Does this sale require Assembly Bill 968 disclosures? Make sure you receive the contractor information and building permit documentation you're entitled to. Step 3, verify the permits independently. Just don't accept a list or file it away. Actually check with the local building department. Permits are public record. You can verify that the work was permitted, inspected, and signed off. This takes some effort, but it's worth it. Step 4, get a thorough home inspection. Assembly Bill 968 gives you more information, but it doesn't replace professional eyes on the property. Use the contractor disclosures to guide your home inspector toward areas of recent work. Knowledge is power in real estate. Assembly Bill 968 gives you more knowledge. Use it. By the way, I recommend a full suite of inspections. The home inspector, also known as property inspector, is a generalist. Heating, plumbing, electrical, roof, chimney. What I like to do, and I recommend, is a full suite of inspectors will arrive at the property, preferably following the home inspector, who will call out issues requiring a specialty. For instance, a chimney inspector, a roof inspector, a termite inspector, a foundation inspector, and we also have the main drain leaving the house, that is the sewer lateral line inspection. So don't be cautious about hiring inspectors. It's the best money you can spend when buying or selling a property. If you're on the other side of this, you're the home seller, you've owned the property for less than 18 months, this is what I would do. Document everything. Keep records of every contractor you hired, every building permit you pulled, every piece of work that was done. The California Association of Realtors has updated their transfer disclosure statement. That's a seller questionnaire. The ramifications of non-disclosure by a home seller can include rescission of a sale, liability for damages. That's far more expensive and far more stressful than just being transparent up front. Disclosure protects homeowners as much as it protects the home buyer. Assembly Bill 968 isn't flashy. It didn't make the headlines. Most people have never heard of it. But for California home buyers, especially anyone looking at a recently renovated property, it's real protection that matters. That's exactly why I started this series. There are laws in the books right now that can play a role in your home sale or your home purchase, and nobody's talking about that. I'm Pat Kapowich. I'm based here in my hometown in the heart of Silicon Valley, and I've helped navigate home buyers and sellers through hundreds of transactions, through every imaginable economic cycle in our housing market. And I've done that successfully by paying attention to the standard of care and the standard of practice. So subscribe to Housing Market Savvy, because this is just the first episode in the Laws That Didn't Get Much Attention series. If you or someone you know is thinking of making a move in Silicon Valley or surrounding areas, reach out. And if you're outside of my service area, I will find a credentialed real estate agent who can help you in your market. Thanks for listening. I'm Pat Kapowich. This is Housing Market Savvy.